one of our own, Kwam Baffron Abronye, has been arrested, remanded by a court, which is supposed to be a court of justice under normal circumstances. The party considers this a constitutional outrage. The arrest itself, the so-called prosecution, and the remand. But before I set in motion the submission of the party expressing its view on this disturbing matter, let me refer to the 2015-2016 One Supreme Court of Ghana Law Report, specifically at page 175 in the matter of Martin Pegu number 2 versus the Attorney General number 2 in writ number J1/13/2025. This reported case was delivered on 5th May 2016. I shall rely on the general view of the courts in their declaration. Quote, Article 19C of the 1992 Constitution has given a suspect under investigation or an accused on trial the benefit that he was innocent until the court had found him guilty after a hearing or following a plea of guilty. The grant of bail was one of the tools available to the court to ensure that a suspect or an accused, as the case might be, was guaranteed his innocence until the court had found him guilty. The presumption of innocence in terms of Article 19(2)(c) of the Constitution embodied freedom from arbitrary detention and also served as a safeguard against punishment before conviction. It also served as a preventive measure against the states from successfully employing its vast resources to cause greater damage to a person who has not been convicted than he could inflict on the community. Therefore, any legislation outside that said so, that will be clearly contrary to the letter and spirit of Article 19(2)(c), which has guaranteed his innocence until otherwise declared by a court of competent jurisdiction. End quote. And specifically, my Lord Doche, JSC, who was part of the majority at page 176 of the law report, said in these veritable words, which I quote, Article 19(2)(c) of the Constitution takes precedence in the laws of Ghana, and any law found to be inconsistent to this constitutional provision must, on the basis of Article 2(1)(a) and 131(b) of the Constitution of 1992, give way and be declared inconsistent and in contravention of the Constitution 1992. In my opinion, Section 96(7) of Act 30 as amended is one such legislation that is inconsistent with the Constitution. The general tenor of Section 96 of Act 30, which deals with grant of bail in general, therefore gives very clear indications. On the whole, the courts have a discretion to grant bail to persons appearing before them in criminal cases upon conditions stated therein. The ousting of grant of bail in Section 96(7) is therefore odd and unnecessary interference with the discretion of the courts. The lead judgment of the court delivered by my brother Benin JSC, striking down 96(7) of Act 30 as amended as unconstitutional, in which I concur, is not a carte blanche for the court to admit every Tom, Dick, and Harry to bail pending trial, because the removal of the statutory shackles in the impugned Section 96(7) of Criminal Code Offences Act 1960, Act 30. On the strength of these, I set in motion the concerns of the party in respect of the remand of Kwam Abronye, our Bono regional chairman. Ladies and gentlemen, this evening, the party is here deeply troubled by what is happening in our country. What has been done to Mr. Kwam Abronye, also known as Abronye DC, our Bono regional chairman, is a profound constitutional wrong. It must be condemned without equivocation, without apology, and without delay. The arrest itself, the prosecution and remand of a citizen for words spoken in the public square is not justice. It is persecution. Now let me be honest about where the party stands. The party does not condone irresponsible speech. We never do, and we never will. Public discourse carries responsibility, and we believe deeply in that. Where speech genuinely damages a person's reputation, Ghanaian law already provides a remedy, a civil remedy, measured, proportionate, and designated precisely for that purpose. It's been designed to achieve one aim: to allow a person who is injured to resort to civil reliefs. But what Ghanaian law does not provide, and what it was never designed to provide, is the conversion of a civil grievance, assuming without admitting that one even exists in this case, into a criminal prosecution. It does not authorize the marching of a man before a circuit court, the stripping of his liberty, and his consignment to state intelligence facility. That is not justice. That is the iron fist of state power wearing a legal glove. On the 13th of May 2026, Mr. Abronye was arraigned before Circuit Court 9 here in Accra. He faces 2 counts. First, offensive conduct conducive to breach of the peace under Section 2071 of the Criminal Offences Act 1960. Second, publication of false news under Section 2081 of the same statute. And what is the foundation of these charges? A social media video in which Mr. Abronye criticized a circuit court judge. He questioned that judge's impartiality. He questioned the conduct in the discharge of the public duty as provided for in the judge's judicial function. That is the sum total of his alleged crime. He spoke. He criticized a public officer. By the way, since when did criticizing a judge become a criminal offense in Ghana? Section 2071 requires conduct that is likely to occasion a breach of the peace. Political criticism of a public official, however sharp, does not meet that threshold. It is protected expression under Article 21(1)(a) of the 1992 Constitution. And the false news charge? A man expressing a political opinion about judicial conduct is not publishing false news, not by any honest reading of that provision. This prosecution of Abronye is built on sand, and we, the party, will watch it fall. The bail denial. A judge who forgot his oath. By the way, that was not his first. Let me turn to what happened in that courtroom. It demands its own separate and pointed rebuke. Counsel for Mr. Abronye presented a bail application. He argued on solid grounds. The charges as we all know, are misdemeanors. The accused, as it was made known to the court, has a fixed place of abode. He is a known public figure with reliable sureties. His health and family responsibilities were placed before the court. The prosecution opposed bail on one ground only, that Mr. Abronye, if released, was likely to commit similar offenses. I repeat, according to the prosecution, in opposing the bail application, it said that if Mr. Abronye is released, he was likely to commit similar offenses. In other words, the state asked the court to imprison a man before any findings of guilt because he might speak again. His offense was speaking. And surprisingly, a court agreed. A citizen was therefore imprisoned, not for what he did, but for what he might say. That is not law. That is censorship from the bench. That reasoning is a constitutional disgrace. It is irreconcilable with Article 14 and 19 of the 1992 Constitution, which guarantee personal liberty and the presumption of innocence. A judge who denies bail because an accused may continue to express political opinions has not administered justice. I say what I'm about to say as a practicing lawyer, as someone who has spent his professional life in courtrooms, who has profound respect for our judiciary and deep admiration for those who carry the weight of dispensing justice. I say this not in anger, but in fidelity to the Constitution I have sworn to uphold, and with all the candor, humility, and respect I can command. When a court denies bail not to serve justice, but to serve silence, it has administered political censorship from the bench, and that, with the greatest respect, is a betrayal of every principle that gives judicial office its authority, its dignity, and its legitimacy. Now, let me specifically deal with the nature of the remand. It was a BNI remand, and indeed, even so, there is a missing court order. No court order drawn. Every remaining doubt about the political character of this prosecution is removed by the decision to remand Mr. Abronye into BNI custody. The BNI, by law, is Ghana State Intelligence and Security Service. It is not a remand prison. It exists to address genuine threat to national security. Mr. Abronye posted a critical video about a judge. That is not a national security matter. It never was. This has nothing to do with the criminal justice and everything to do with political intimidation. But there is something even more alarming. I want every Ghanaian to hear this clearly. Even those who hate the guts of Abronye must at least listen to this matter. It has now been 4 days since the court pronounced the remand order. 4 days, as I understand it, on the basis of information available to the party at the time of this statement. Counsel moved up and down the courtroom, the registry, demanding for certified remand order. The court order, as at Friday, has still not been drawn. I therefore simply ask a simple question. On what legal basis did the Ghana Police Service take Abronye into custody and conveyed him to the BNI? On what legal basis did the BNI accept and held him? A remand order is not a verbal instruction. It is a formal judicial instrument. It is a written legal authority upon which the deprivation of a citizen's liberty must rest. Was a Ghanaian citizen delivered into intelligence custody or nothing more than a word of mouth? If so, That detention has no documented lawful foundation whatsoever. So I ask again, the Director General of BNI, did you receive any court order accompanying Abronye's detention? If so, can you provide a copy? If not, why did you accept him? And I asked my Lord, if my Lord thinks he is bold enough, why is he running away from his own court order? By the way, that Circuit Court 9 records are immediately tied. As you are making your submissions, the clerk is typing. So within 5 minutes after court, the records of court must be ready. Why has it taken days? And as at close of business Friday, the order was still not ready. What is the judge trying to tell us? Is he trying to change what he has said in open court? That Abronye should remain in custody until the case is finally determined, not even to the next agenda date. His language was clear. Is he running away from his own language? Is he afraid of public outrage against his own conduct? Article 14 of the 1992 Constitution requires that no person shall be deprived of his personal liberty except as permitted by law, and that every arrested person shall be informed immediately in a language he understands of the reasons of his arrest. The Constitution therefore puts before the Ghana Police Service, the Bureau of National Investigation, as well as that Circuit Court 9, which was supposed to be presided over by a judge who has taken a judicial oath, a clear and unambiguous notice of the civil liberties provided for by the Constitution. These are rights guaranteed, far rights. The production of a signed and certified remand order is not a technicality. It is a constitutional imperative. Its absence, if confirmed, would rather render this detention not merely improper but unlawful. What we are witnessing is either a crass dereliction of duty or a raw and deliberate exercise of power designed to show a political opponent where the power lies, with due process and afterthoughts. So the NDC party functionaries who are encouraging this, you should know that your 4 years is now left with some 2.5 years. Your time will come. Those judges should know that President Mohammed's tenure will soon come to an end. They should know this. That God willing, 2028 will be Dr. Bawumia's turn. Indeed, we are reminding them that neither explanation is acceptable in a constitutional democracy. Both demand accountability. Now we see the ghost of criminal libel coming back, buried by Kufuor, but resurrected by President Mahama. There's a deeper dimension to what this government is doing, and it must be named plainly. On 27 July 2001, Ghana's parliament unanimously passed the Criminal Code Act 2001, Act 602, which repealed the criminal libel and seditious laws. President John Agyekum Kufuor gave his assent on 2nd August 2001, striking from our statute books one of the most notorious instruments of state censorship this country had ever known. That repeal was a defining moment in Ghana's democratic maturation, a declaration that in free society, the state has no business imprisoning citizens for what they say. The bill was presented to Parliament by Nana Addo Dankwa Akufo-Addo the Attorney General as he then was. The world applauded. Ghana was held up as a model for Africa. But before we go further, let me be precise about one important historical fact. The criminal libel law was not created by the PNDC or NDC. It is a colonial inheritance drafted in 1893 by the British colonial administrators and embedded in our statute books to suppress dissent against imperial rule. Dr. Kwam, our first president, inherited it at independence. It was codified in our Criminal Offences Act 1960. The law predated the Rawlings era by decades. But what history will never forgive the PNDC and NDC for is this. They weaponized that colonial relic most ferociously, most systematically, and with the greatest cruelty against the citizens of a free Ghana. Under PNDC military regime of Jerry Rawlings, journalists, academics, lawyers, trade unionists, and ordinary citizens were arrested, detained without trial, and tortured for daring to speak. The culture of silence was not a metaphor. It was a lived reality enforced by brute state for power. Mr. Tommy Thompson, publisher of Free Press, and Mr. Michael J., a senior writer, in 1982, were among those in prison without trial for editorials critical of the PNDC. Mr. John Kublenu, the editor, was separately arrested in 1983 and detained without charge before being transferred to Insawam prison. He died in 1984. Shortly after his release, his health destroyed by the conditions of his detention. He was never charged. He was never tried. He simply died for daring to write. Tommy Thompson himself continued to face harassment and repeated prosecution and died in 1998. His death, a direct consequence of brutalities he endured in his long fight for press freedom. 2 men, 2 deaths. The blood is on the hands of that regime. Abdul Malik Kwekubaku Jr. was arrested and tortured under the PNDC. He has spoken publicly about being made to crawl the full length of Military Parade Square on his knees until they bled. About being caned on his waist. About 25 days at the Fields Engineers facility that left him physically impacted. About losing control of his bodily function for days on end, all for speaking truth to power. Kwesi Pratt Jr. was jailed and tortured during that same period. So was Akotampa and many others whose names history has not fully preserved. Then came the NDC in constitutional form. And even under the democratic dispensation, the party found uses for the criminal libel law it had inherited. On 23 July 1998, 2 of Ghana's most respected newspaper editors, the same Abdul Malik Kwekubaku Jr. of The Guide and Alhaji Haruna Atta of Weekend Statement, were convicted by the Court of Appeal and sentenced to 1 month in prison. Their crime? Publishing a story about the former First Lady. They were dispatched to separate prisons, Akuse, Winneba, and Anumabo, in a deliberate attempt to break their spirits and prevent visits from supporters. Images of Kwekubaku and Haruna Atta in handcuffs being marched to prison are etched in the collective memory of every Ghanaian who loves freedom. In 1996, editors Nana Kofi Kumsin of the Ghanaian Chronicle, Ebenezer Kwaku, and Tommy Thompson of the Free Press were arrested and charged with publishing false news with intent to injure the reputation of the state. Those exact words, publishing false news, the same statutory weapon this government is now deploying against Abronye. And when the court came to repeal the criminal libel law, the then NDC chairman, Obedi Awasamwa, who had also served as Attorney General under Rawlings government, declared publicly that the law could be repealed over his dead body. Over his dead body. That is the NDC's historic relationship with free speech. That is the tradition President Mahama now chooses to continue. The MPP abolished the law that the NDC swore to keep. And now the NDC is quietly rebuilding what the NPP tore down. Now the Mahama administration, unable to openly reverse that landmark reform without international condemnation, has chosen a more cunning path. Rather than restore criminal libel by name, it is reconstructing the criminal libel regime in practice, hiding behind sections 207 and 208 of Act 29 to achieve through the back door what it cannot defend through the front. The charges against Abronye, Baba Amando, David Esando, and others are in substance and in effect criminal libel prosecutions. The only difference is the label on the charge sheet. The intent is the same. The mechanism is the same. The consequence is the same. Arrests, remand, imprison, silence. President Kufuor abolished criminal libel to set Ghana free. President Mahama is rebuilding it brick by brick to cage opposition. So I ask President Mahama, is this the legacy your second coming is leaving Ghanaians with? I pray it is a no. When civil remedies exist, criminal prosecution is a political choice. I repeat, when civil remedies exist by law, criminal prosecution is a political choice. And that is the choice this government has made. I made this point earlier in these proceedings when I started. And I return to it now because it deserves to be stated plainly and in its full legal force. Ghanaian law already provides a civil remedy for any person who genuinely believes they have been defamed. It has always been there. It exists today. The aggrieved party may approach the civil courts. They may sue. They may place their case before a judge. They may walk away with their reputation vindicated and with damages in hand. Not a single arrest is required for any of that. Not a single bail application. Not a single remand into BNI custody. The civil law achieves the stated objective, the vindication of reputation, without any of those consequences. This government knows that or ought to know that. Its lawyers know that or ought to know that. The prosecution officers know that or ought to know that by their training. And yet, case after case, the criminal route is chosen over the civil one. That choice is not a legal necessity. It is a deliberate political decision. And the purpose it serves is not the vindication of any reputation. It is the suppression of voices. When you want to protect your name, you go to the civil courts. When you want to punish and silence an opponent, you send the police. This government has made a choice, not once, not twice, but repeatedly and with the purpose. The Ghanaian people can see it exactly for what it is. Now we can see a pattern, not an incident. Ladies and gentlemen of the press, let no one tell you this is an isolated case. The arrest of MPP members for things they have said or posted in public are too numerous to catalogue here. We have documented case after case since this administration assumed office on 7 January 2025. The list grows longer by the week. Let me mention just a few. David Esando, MPP Aguna West constituency organizer, arrested by approximately 10 armed national security operatives. His crime? Posting an image of President Mahama with the caption, Dumso is back. But isn't Dumso back? 10 armed officers for a Facebook post about electricity outages afflicting millions of Ghanaians. Then Mr. Abubakar Yakubu, MPP Sunyani East Communications Officer, popularly known as Baba Amando, arraigned before an Accra Circuit Court, remanded, charged with offensive conduct, false publication and circulation of statements likely to incite fear and panic. The same judge, Circuit Court 9, the Agenda Court, the NDC Court. And let me repeat it. That NDC judge, he must be ashamed of himself. Mr. Alfred Abebi Okumi, known as Adente Kumi, was arrested by operatives of the National Investigation Bureau in a dramatic dawn raid on his home. His wife suffered a miscarriage as a direct consequence of that raid. His crime? Submitting a petition to the president concerning the conduct of committee members sitting on the Chief Justice removal proceedings and making comments in media interviews and on social media about the same matter. He was formally charged with publication of false news under the same statutory provision being used against Abronye today. And there's a case of Reverend Intim Fojo, a member of Parliament for Asin South, and a ranking member of Defense and Interior Committee of Parliament. This is a sitting member of Parliament, a duly elected representative of the people. Again, BNI operatives attempted a raid on his residence after he raised concerns about 2 aircraft that visited Ghana and alleged possible links to drug dealings and money laundering. It took his colleagues in the minority caucus to physically resist attempted arrests. Dr. Baumia, our flag bearer, himself had to visit him to reassure him that a member of parliament should require reassurance that he remains free after raising matters of national security concern in the discharge of his public duty is a statement of the most alarming kind about where this country is headed. And now Abronye, remanded into BNI custody for criticizing a judge. There are no isolated incidents. They are selected examples from a deeply troubling and growing list. That judge has no respect for his own judicial oath. I don't think he read the law. That Circuit Court 9 judge, I have no respect for him. For a judge to say that he's remanding Abronye into BNI custody until the case is finally determined, such a judge can never have my respect. I pray that he summons me for contempt. I will continue to disrespect him until he upholds the law. He's gone beyond his judicial function, and it is not his first. It's as if he has been selected purposely to achieve this. He doesn't talk law. I don't know whether he ever passed his law exam. It's a shame. It's a shame on the judiciary. And my Lord Baffron must pay attention to this. For whatever it is, it's about his legacy. I'm told by December he will be 70 and he will be gone. Is that a legacy he wants to leave? After Tokonu was booted out of office and all manner of accusation leveled against Tokonu, is that the judiciary? The judiciary, they said they were going to reset. Is that the reset? Where a judge will say he is remanding an accused, because if he allows him to go home, if he grants him bail, he is likely to talk again. So he should remain in custody. In fact, at first, his pronouncement was that Abronye should go to Nsawam until the case is finally determined. He's already prejudiced the outcome of the case. And this man says he's a judge. I should respect him. No way. And some fool say, Yediche. Eyenim gwase papa. Ebufusem. Our flag bearer, Dr. Muhammadu Barumia, has rightly described as an unholy collaboration, this conduct, between the executive, state investigative agencies, and some element within the judiciary aimed at silencing the MPP. He is right. More than right. The pattern is undeniable. This is state-sponsored political persecution, and it must stop. Now, a word to the judiciary. You are to be the guardian of liberty, not instrument of power. I now address you, my respected learned members of the bench, and I've used respected advisedly. And I do so with gravity. This moment demands. The 1992 Constitution, my lords, vests judicial power in your hands as the judiciary and charges you with a solemn mandate to be independent guardians of the rights and liberties of the Ghanaian people. Article 1253 declares that judicial power of Ghana shall be vested in the judiciary. Article 127 fortifies that with the guarantee of independence. These are not ceremonial provisions. They are the constitutional foundation upon which every citizen's liberty ultimately rests. It is with the deepest concern that this party NPP observe how the courts have conducted itself in this matter. A bail application grounded on orthodox legal principle was dismissed on a basis that no serious reading of Article 14 and 19 of the Constitution can sustain. A citizen has been remanded into the custody of an intelligence service on misdemeanor charges. What has happened to the old principle of law? That should all men find a man's hand in a tail, his guilt must be proven. Under his lordship, Baffron's leadership, you are guilty before you are pronounced guilty. You are guilty before full trial. So my Lord Baffron, Embredudua waye judge, anyamia dum, omutu tokonu yaya ubedi Chief Justice. Sadia wena wudija Ghana. Nimkwasio my Lord. Bieweni na hwede ekofom ekoso wo fomo. Se judge otumika se obi nko remand. So say yebedi na se mewie. Ekumu nyina mo enimu ase. Supreme Court judges, Court of Appeal judges, High Court judges. Monsore nkasa. Na de ekoso no ekumu nyina mo enimu ase. Ye de mo a mo begum hu fi no. Ye mpampa mo ye be kasa, mo pe amon remanding. Mo pe mo nka contempt na mo fa ye nko prison. Ye be ko inso. Ye na nanu mo mo de party be bo ase no. They went through similar ordeal. It never broke them. At every turn, the scales have tilted not toward the protection of liberty, but toward its curtailment. A court that allows itself to become a tool for silencing political opponents has ceased to be a guardian of liberty. It has become a participant in its destruction. I am aware of the climate in which our judiciary is operating. I am aware that this is a government that has shown it is capable of defiling our constitution to haul a sitting Chief Justice out of office. I am also aware that some members of the judiciary may be afraid. They look at what was done to Chief Justice Tokonu and ask themselves whether standing up for the constitution is worth the personal costs. I can understand that fear. But there are some also who are still wearing partisan colors and are refusing to look at the law, and they are bent on taking backdoor instruction from the executive to do their bidding. Those must change their attitude and respect the human rights of every Ghanaian, irrespective of their party color. The people of Ghana look to the courts as the last line of defense when the executive overreaches. The trust is earned by the fearless and impartial application of constitutional principles, especially when the person before the court is politically convenient to those in power. A judge who surrenders to fear and becomes a timorous soul, too intimidated to defend the Constitution and the rights it protects, is no longer a judge. He has become an instrument of the powerful. A court that reserves its constitutional courage for safe and inconsequential cases and abandons it precisely when it matters most has dishonored the robe. I call upon the High Court to take urgent cognizance of the circumstances of Mr. Abronye's detention, including the reported absence of a signed and certified remand order, and do the needful. Now, Ghana has been here before. The culture of silence does not announce itself with a decree. It does not arrive at your door with a proclamation. It arrives as likely like this, incrementally and surgically. A communicator of a party is arrested. An organizer is picked up there. A regional chairman is remanded into security remand. The message is spread quietly through every rank of the opposition. This is what dissent costs. The Mahama administration has calculated that intimidating MPP communicators and silencing its regional leadership will allow it to govern without accountability and shield its mounting incompetence from scrutiny. That calculation is profoundly wrong and it will fail. It will not work. The MPP will not be guarded, not by arrests, not by bail denial, not by BNI detention, not by any instrument of fear this government deploys. The freedom to speak, to criticize power, and to hold government accountable is not a privilege granted by any administration. It is a constitutional birthright, and it cannot be revoked by any government on earth. Abronye's voice may be temporarily caged. Let the government understand clearly. 1,000 voices will rise in its place. And that is not a threat from the party, but rather it is the unbreakable promise of Ghanaian democracy we are reiterating. Now our demands. We make the following demands, and they are non-negotiable. First, Mr. Kwam Abronye must be released from BNI custody immediately. His detention is constitutionally indefensible and must end today. Second, our legal team will mount full constitutional challenge to this prosecution, including challenge to the application of sections 207 and 208 of Act 29 against political speech where civil liberties are available and adequate. Third, Parliament's Constitutional, Legal and Parliamentary Affairs Committee shall, upon assumption of Parliament, be made through an application to summon the Inspector General of Police, the Director General of BNI to publicly account for every decision taken in this matter. The Chief Justice is not also above the law. Parliament will use every law under its command to summon the Chief Justice. They must all be answerable. And let the majority know this. In the effort by the minority in ensuring this is done, they should not try to stampede it. It is good for democracy, and we call on the majority to support it, because tomorrow they may be in opposition and they may need this very law to protect them. I repeat, for our friends in the majority in Parliament, I call for their cooperation, even as the minority in summons the Chief Justice, the IGP, and the Director General BNI to appear before Parliament. They should support us. They should cooperate. It is a democratic responsibility. They shouldn't, for partisan consideration, decide to stampede us with their numbers. If they do, one day, they will regret it. If they do, they may win with their numbers. Sure. But one day, by 2029, They will be shouting on the rooftops, asking for the law to protect them. And we'll tell them that when the time came, they condoned, they connived and supported it. We pray that day will not come. We need to end this vicious cycle in our political system. It is better for this country to sit together and work around the relevant issues that would ensure the growth of our democracy. And that is our demand on the NDC today. Again, we call on civil society, independent media, and legal profession. They must add their voices now. The time to defend freedom is always before it is fully lost, never after. Again, we call upon the High Court to take urgent cognizance of Abronye's detention and the reported absence of a signed and certified remand order. The writ of habeas corpus exists for precisely this moment. The judiciary is the last line of defense between citizens and the unchecked power of the executive. We call upon the judiciary, if indeed it is there to uphold justice, to intervene and treat it as an isolated situation. Then we can respect them, then we can trust them and believe them that it is not supported by the system as a whole. And again, the conduct of this judge at Circuit Court 9 is now a pattern. They should call him to order, and we should see a disciplinary action by the Chief Justice against this judge. Finally, ladies and gentlemen, let me say on behalf of the party that the people of Ghana made a solemn covenant with themselves and with history. They said, never again shall the machinery of state be turned against citizens' right to speak. Never again shall political opinion be treated as criminal conduct. Never again shall the instrument of national security be weaponized to detain political opponents for the convenience of a certain government. And to those in this government, I repeat, who believe they can abuse power without consequence, I say this clearly and on record. The day of justice and accountability will come. It will come under this parliament or the next, but it will come. That is not a promise. That is a constitutional certainty. We built this democracy to last. We will defend it in the same courts where there seems to be some injustice. In parliament, where there is advocacy of the people. And in the full glare of public opinion like this platform, the party has chosen to speak. With every constitutional weapon at our very disposal. The culture of silence Central for wish him or Imbri. The Imbri Yabaka Wanensa. Oh, yeah, New Patriotic Party, Amayoko. Yes, the Imbri and our whole and Yamunisha and the President Imbri. Yes, some already there. Sabio, say Obri Yazibia on Fata. ayan party ni yemfo do de sebe obi nkesha ahoroba anon kese nchi obi na mbom wo Ghana mbremun so obi kakase bi na onsam fata was not from Brakwando sebe maya constitution aka no so obi kase chi obi iwo kebmemin kedma won bon nkwedu won fa no court za ye hunyi de NDC fo since awoba abenum dam kwedu bo na woti riye dwuma sebe obi kasa wo MPP na wonyim do ohon wana na was nhunhun yani won kase za man na koside ye hye wa hin de yen bono regional chairman a wo friend Abronye a police fo se okakase ti a judge bi na kasa okakase chairman no was in a court oyahwe wako ogodu court no judge a otne gum na asam nye de se woma Abronye bela anhwa na wakakase bio inti was ordinary to fiase ordinary to prison until they will be asem na wi na wombrem no se wombu ufo a intum nkovia efiase na judge na asam na ranke wi nanso edikan ezinyimpa na akoto remand ona make dikan kade wo ya ye Supreme Court oye onyimnyamfo Martin Pebu oye lawyer mbrebi abasen kodam nsami wo ma bail wo ba ma bail wo ma bail wo ba ma bail onunti oda sam ko free court ama Supreme Court ka say kade debi bail ze unhia de oye de was manyimpa osande until de nyimpa no wo bezi na asem ewe bu no fon intum nka de edine court fiaze na za punish inti bail asem zo ya za what can wasam that the court ibio ye wo offenses bi obaka do dama bonize nanu yesho ene ye wo za bronyi kade misdemeanor chada oye bibi kitikiti bia onyaza oye hu na za wasa Abronye akoye okadam misdemeanor ayi embrano hu inti sadamu mpo a eba dintino e de judge kade ozne ko to prison ozigan kade ozne ko nsawom ansana ibi o wakado ozne ko ayi BNI fitida omani ruling there ozne ko to remand nanu court odempo onto min sign meanwhile court game one onye manual court or a digital court rekase nyina na wo type into within 5 minutes after proceedings or there at least clerk and autumn print judge why is serious when ejumum within 5 minutes or do autumn can nanu ruling no na o sign asa the fide nyumbri na nankasa no ruling pon sign into questioner and people be saying there BNI fo was it Abronye call one channel eba krata na ozechi police fo no so was it Abronye call BNI eba krata na was ye ngina do ana anu keke na was ken no onu nti yan kasa ni wie yan de o man pen mahama yankopon na adom inyo bia no nya second chance presidency inyo bia no nya second chance adom keke into man pen mahama yesre aka won fi beye ebien na fa na ze wedwuma abewie yi yankopon na adom ma woso asom woman for them 8 years na oda wakomado iti jewechiye o man pen mahama ya sam nyi de jewechiye na ochina o pa bibi tuwa ochina bi ni wa Ghana wobobo wuzin was akasam na bia na efo na judges na police fo no enziye bia wo yen se ma wanyu nko ho se nyim ho hwea ma wanyu nko ho o man pen mahama yenuanum so wo NDC mo onye hon daw de inde oye MPP ni na ochina wo ho na no otumfo se embre ni zen emimenti twi no mezenye fante otumfo ose embre eninkaso enti yenuanum a wo parliament oye NDC fo parliament boye ya woda Yebo someone minority. Yebo someone BNI Director General. IGP. No only Chief Justice. The judge na all ya damazin yam shene yan kanwasam. Abronye na samano yanda wo ho. Na wana wo invoke them section 207 na 208 ne pede ya kanwasam. Yesterday yan nuanum NDC for our parliament. One boy. Na yam fe ye into ye. Dem brebe ye ochine bi abebi ba. Na someone so opposition. Na wo di wana asam ya ye a otedama. We tum we use mbrano. Na was aji one fanguzi. Na say why you working there? Business as usual. Why your politics into one man kon because they have 2/3. Inyanze yenyutum yabaka na was one numbers what they win votes. But one came with there so one supporting. Na yentum yamfanza man 2 year ya. Ochinebi na power bi aba. Because already no they are on their way out. Why won him? The 2028 will lose one win. Into him they will lose election 2028. Then him there President Mahama on baby as Nejuma Benewi. It is your own interest. The injustice be a and then able to tune ye am watching a minister neko one whom jima. I assure the day and brebi or wa over protector. Naza one yana dama honors a wara. Yes, yes, my be, yes.